Good afternoon, everyone, and welcome to this Court of Protection case law update today. I'm joined by Mary, Rachel and Gemma and Ray, who's helping us with the slides. And everyone who has signed up has, I hope, had a copy of our legal action group case law update from the July-August edition of Legal Action. If you've been to these sessions before, you'll know that we deliver them in tandem with our articles for legal action. So you get the legal action article, and then we're able to provide some further updates of developments since the article. If for any reason you haven't got the article, I think Ray's put it in the chat. And a reminder that the slides will be put up on our website, as will the recording once this is done. But please don't leave us just because the recording will be available. I'm going to turn to Gemma, who's going to start. We'll each be speaking for just over 15 minutes, and we'll have some time for questions. Over to you, Gemma.
Thanks, Sophie. Next slide, please, Ray. So I'm going to be talking about a number of first instance decisions from the last few months. The first one being the most recent COVID vaccination case. In the lag update that Sophie mentioned, you've got the summaries of the previous COVID vaccination cases, but this being the most recent one before Her Honour Judge Brown. And this was about a man in his 30s, AD, who lived in supported living with 24/7 care and support. He was diagnosed with a moderate learning disability, Down syndrome, autism, and was clinically overweight and of Black and minority ethnic heritage, which were all factors that, as we'll all know, make him clinically extremely vulnerable to COVID-19. His particular circumstances were that he had significant health anxiety and found health interventions distressing. So he consistently refused to engage with them, and it was anticipated that the same would be the case with the vaccination, which was interpreted as being his wishes would be to object to the vaccination. And he was, however, a sociable person, which put him at additional risk in terms of coronavirus, because he wasn't able to comply with social distancing, wearing a mask, all those PPE and protective measures that we're all familiar with from the last year and a half. Next slide, Ray. The application was actually brought by the CCG, who didn't have a direct role in his care, but brought the proceedings to ensure they were before the court because there was a conflict in the positions of the professionals and P's father and P's mother. So the CCG said that COVID vaccination was in his best interest, the benefits would far outweigh the risks, and his father and all the professionals agreed, whereas his mother disagreed with that. Next slide, Ray. In terms of the his mental capacity to make decisions about the vaccination and any medication to facilitate its administration, so noting there that it wasn't just capacity assessments for vaccination, but also for his anti-anxiety medication and pain relief medication that would be part of his care plan for vaccination, there was agreement by everyone that he lacked capacity. And there was capacity assessments both from the care provider's manager and a senior community learning disability nurse. Next slide. The issue was really about mum's concerns, so P's mum's concerns that were specific both to P, to AD, and to the vaccine generally. So she had concerns about the impact on P personally, the circumstances in which he would receive the vaccine. For example, she was concerned about the use of force. In fact, the court said no force or restraint was proposed, and it wouldn't be authorised either. And she also had concerns about vaccination causing distrust because of his disagreement or his resistance to medical interventions. So the plan in relation to that was that there would be a mild sedative and be given to him in the morning before vaccination. It would be set up where that he would be ready for the vaccination with a short sleeve top on for quick access, and the nurse who gave the vaccination would not be part of his care team so that he wouldn't associate in terms of distrust with that person. It wouldn't be someone who cares for him normally, and he would be distracted by carers at the same time. There were other concerns that P's mum had, such as he might exhibit uncontrollable behaviour with pain and hurt. And then in terms of the COVID vaccine generally, she raised concerns that were described by the CCG's council as well-known, extraordinary and dangerous misinformation concerning the COVID vaccine of the kind which is rife online. And the CCG submitted that it should be given no weight. There were other concerns she raised that were not described in that way, but some of the concerns were that kind of misinformation as it was described. Next slide. The concerns of P's mum were taken into account, of course, under the Section 4 best interest analysis. They need to be, but they were not determinative. So as with the other COVID vaccination cases we've seen, family members who object to vaccination being in P's best interest is not going to be determinative necessarily of whether vaccination is in their best interests. And in this case, you also had P's own opposition to healthcare interventions, that vaccination would be contrary to his wishes and feelings. Again, that was not determinative. It was taken into account, it was weighed in the balance, but with all the other evidence and with all the evidence from the medical professionals and other professionals involved in P's care and P's specific risk, the court determined that vaccination was in his best interests because the risks of coronavirus outweighed the risks of vaccination in accordance with that proposed care plan. And it's important to note that in this case, there was a very detailed and carefully considered care plan that had been scrutinised by the official solicitor that was specific to P, so ensuring that the vaccination process would be in his best interests, specific to his needs. And in this case, which was before we had the guidance on the booster jabs, the booster was not authorised, so there wasn't any policy advising for boosters at that point, but that may well be different in future cases now that we have the guidance that we have. Next slide, please. So that's the COVID case, sort of to keep us updated in addition to the lag updates. The next case I'm going to talk about relates to capacity or determining capacity in the context of contact and sexual relations. This was a case about a 24-year-old man who'd had a difficult family life, a difficult childhood involving sexual abuse, in addition to his own sexually inappropriate behaviour towards younger people. He'd been living in a residential home from the age of 16, and from the age of adulthood, from 18, he'd had a standard authorisation in place. He had a learning disability, which was described as once being thought to be severe, but then moderate, and he had autistic traits and a mood disorder. And the circumstances were that he'd begun pursuing sexual relationship with others online, mainly men, and on occasion he'd absconded to arrange to meet with people for sex. He'd also used alcohol, which in circumstances that caused concern to those concerned with his welfare. He had tried illegal drugs, and he had developed what was described as obsessive traits regarding mature men that he had contact with, to the extent that he might not eat or sleep if he became obsessive about them. He had to move placements because of concerns about absconding, so absconding in circumstances where he was put at clearly quite significant risk. Next slide. And the concerns that had come about by the point that this case was heard was that he'd been increasingly absconding. There were concerns about not knowing where he was. He was being provided with drugs and alcohol, gifts and presents, and at times he'd be missing for days. And he revealed he had had sex with random men, and there were concerns about him being, what he clearly was, being exploited. The restrictions had increased in response to that, which he didn't respond well to. That's how it's described. And he'd moved to the placement he was in at the time of the judgment in September 2019, but continued to abscond, continued to use serious drugs, and continued to go back to the area he'd previously lived in to meet with men that had been involved in exploiting him sexually. Next slide. He had not engaged with capacity assessments. So a number of capacity assessments were attempted by social workers. Either he didn't want to engage, or he was under the influence of drugs, or he wasn't there because he'd absconded from the placement. And the independent expert who was instructed, Dr. Natalie Brotherton, clinical psychologist, also had difficulty engaging P in her assessment. So you've got a case where there's missing information, there's incomplete capacity assessments, less than ideal, less than what you'd expect to have usually when assessing capacity. And Dr. B assessed him on the basis of what she had been able to assess from her limited engagement with him as lacking capacity to make decisions in relation to litigation, care, residence, and his contact with others. But he had capacity, she assessed him as having capacity to engage in sexual relations and use the internet and social media. And she'd not really been able to assess him, so the presumption applied. And she was clear that his diagnoses were the cause of his lack of capacity in terms of the causative nexus being satisfied. Next slide. The judgment of the court was that on contact, the evidence of Dr. Brotherton was accepted. So in terms of contact, there was discussion around the risk of exploitation of P because he didn't understand nonverbal cues and more subtle social behaviour. He would only hear the language. So he could respond, she said, to concrete observations, for example, that somebody was nice because they'd given him drugs, which he enjoyed. There's an interesting discussion in the case about behaviour that is typical of a 24-year-old, so consideration that the expert had given to the fact that he was a man with testosterone, he wanted to have sex regularly, but there were also examples that the judge accepted that showed he was unable to plan in a way that a 24-year-old would be able to. So for example, he didn't charge his mobile phone and he was relying on the police and staff to get him home rather than having his phone charged to be able to arrange that himself. There was also consideration in the judgment of unwise decisions, particularly in the context of a 24-year-old and in relation to drug taking and who they spend time with. But specific to this P, the court accepted the evidence of the expert that his difficulty in understanding social situations, combined with wanting to show his independence and his inability to see or understand the reasonably foreseeable consequences of behaviour, meant that his disabilities led to the risks that other people without them would not face. So some discussion there of that causative nexus of connecting his diagnoses to his functional impairment. Next slide. And as I said, the judge accepted the expert's conclusions, notwithstanding the fact that there were incomplete capacity assessments because P hadn't wanted to engage. And the description that was given to that, the way that the judgment describes it, is that Dr. Brotherton had explained the reasoning for her conclusions, in addition to the social worker's accounts, had actually provided the court with a full picture, despite what might be considered incomplete assessments. In relation to engaging in sexual relations, P had benefited from previous education in relation to sexual activity, and he had capacity in that sense. But on contact, he was assessed, it was declared that he lacked capacity to make decisions about contact with others. He described himself as invincible, being one example of his lack of understanding of the risks that he faces. Next slide. And Her Honour Judge Williscroft in this case said it is, I accept, rather odd that he can understand the basics of sex, but not have the capacity to engage in a relationship that is based almost exclusively on the need for sexual activity. So applying the JB test here, nevertheless, we've still got a case where someone has capacity to engage in sexual relations, but lacks capacity to make decisions about contact. So that unusual dichotomy continuing. And then finally on this case, next slide, Ray. The judge actually sent a letter to P explaining her decision, which is at the end of the judgment. And we do sometimes see that, of course, but it's not particularly common. It doesn't happen in every case. And by reading the letter, I think it shows that the importance of ensuring P's participation, of having that explanation provided to P. And the letter acknowledged that, of course, P's own representatives would explain it to him as well, but having that letter from the judge, unusual, but a very helpful thing to do from P's perspective. Next slide. I've got 2 more cases to get through, so if I start talking fast, that's why. So the next slide is, this next case is a case about coercive control before Mrs. Justice Roberts. And it's a 70-year-old woman with vascular dementia, the issue being whether she should be prevented from having contact with this man, NC, who she considered to be pivotal to her emotional well-being and happiness. And it was a case where proceedings were brought by her daughter, who was essentially estranged from P, as were the rest of the family, but nevertheless brought these proceedings because of the family's concerns about P's vulnerability to harm from this relationship with this younger man. And it was alleged that he was exerting coercive control in several aspects of her day-to-day life, but particularly relating to her finances. And she was vulnerable to that control as she didn't recognize it. I should say that he denied the allegations, but the court found them to be proven and established. Next slide. And importantly, Mrs. Justice Roberts acknowledged that P held a really firm view that she wanted contact with this person. She considered her future happiness to be bound up in a relationship with him. So very strong wishes and feelings to have contact with him. In fact, she hadn't been having contact with him for over a year because of previous court injunctions, but nevertheless, that was her wish. And the judgment includes very early on an acknowledgement that in circumstances where personal autonomy and life choices are a central aspect of the human rights which this court is bound to uphold and respect, it is only in limited circumstances where it can or should intervene. And spoiler alert, the court did intervene in this case and stop contact. So next slide. Just to give you an idea of some of the, next slide, Ray, thanks. Just to give you an idea of some of the conduct that this man had engaged in relation to P, lots of it financial. He had claimed that he'd made all these purchases using P's funds with her consent. She was later assessed as lacking capacity to make decisions about finances. But even purchases, things like a van, a car, a pickup truck, and she didn't drive. And he was using them for his work as a builder. And there was a police investigation. The police estimated that he'd received about £80,000 from her. And this was all in circumstances where he had multiple past convictions for fraud, theft, blackmail, and other offences. And the court did take those into account. And if you have a case where you're considering the circumstances in which and the weight to which the court will give to past convictions, there's an interesting part of the judgment on that, so a useful reference. He'd also tried to liquidate P's investment portfolio. She had quite substantial finances, and there were a number of property transactions in process. And there were also concerns about his control regarding her welfare as well as finances. His response was, the issue is really, this comes down to the daughter's not being happy that she changed her will. The court didn't agree. And the official solicitor's description of him really provides a neat summary that he was a confidence trickster whose long-term lifestyle appears to have involved repeatedly unveiling money from vulnerable people through coercive control, and at least on 3 occasions, blackmail. Next slide, please. In relation to capacity, the man NC, he didn't accept that she lacked capacity to make decisions about finances or about her contact with him. Everyone else did, and the court had a number of expert reports and concluded that she did lack capacity to make decisions about her contact with others and had already decided she lacked capacity in relation to property and affairs. Next slide. In relation to capacity, the one thing to flag is that this is a case where she lacked capacity in relation to contact, and there's circumstances of coercive control. And that coercive control, the corrosive and coercive nature of the control, had an impact on her decision-making from a capacity perspective. Just to flag that, because sometimes those circumstances can raise people thinking about the inherent jurisdiction. So it's an interesting case to see how coercive control can impact on a person's mental capacity. So essentially, because of the vascular changes in her brain, she had vascular dementia, remember, they've resulted in a global cognitive impairment impacting her ability to weigh and use information. And she was blind to future risk as she had been to past risk. So if you've got a case about coercive control, how that impacts on capacity, there's quite a few useful paragraphs in that judgment. Next slide. Ultimately, in terms of her best interests, the judgment was unsurprisingly highly critical of NC. He had exerted coercion and control, and the court decided that it was in her best interest not to have contact with him. There was an injunction with a penal notice against him, forced marriage prevention order, an injunction to prevent him having a civil partnership, so the whole lot. And the court also commented that there would be a recital to the order that it was in her best interest, P's best interest, to have therapy to come to terms with the loss of the relationship, acknowledging the fact that she very much wanted to continue to have contact with him. Next slide. I'll be quick on this one. This is the last case I'm talking about. This is the sequel to Re P, which was Mr. Justice Hayden's discharge of a party that then got appealed to the Court of Appeal, and that discharge of the party was set aside. So it went back to Mrs. Justice Leven. And the circumstances of the case, just to remind you of the facts, was a 19-year-old with cerebral palsy, atypical anorexia, post-traumatic stress disorder, and selective mutism. She'd been living with her mother until she was 16, and then there was a child protection plan. Allegations had been made that she was sexually assaulted by a visitor to the family home. So Mr. Justice Hayden had discharged the mum as a party. That had been appealed and overturned, and it was back to the court for Mrs. Justice Leven to decide if P's mum should remain as a party or not. And the mother very much wanted to be a party to proceedings. And P had revealed in October 2020 that she'd been subject to emotional abuse by her mother through WhatsApp, and her mother had been aware, she said, of the abuse by this man, but had taken no action. And she also alleged physical and sexual abuse by her mother's new partner. So P, by this point, didn't want to live with her mother, wasn't living with her either, didn't want her mother involved as a party, didn't want any relationship with her, and said that she wouldn't be involved in the COP proceedings if her mother was a party. And her therapist provided a letter to the court that she would be very concerned for P's well-being if her mother was a party. Next slide. And Mrs. Justice Leven said that it would be vanishingly rare in a court of protection case for justice to a third party, so thinking about the mother here, to result in a decision which was contrary to the best interests of P. And she took it back to the principles of the Act. There's always two questions. Does P have capacity? And if not, what is in P's best interests? And in this case, by the time this hearing was heard, it was very clear that P did not want contact with her mother. To the extent that the judgment says, in my view, whatever Article 8 rights AA, that's mum, had in relation to P in respect of her earlier evidence, which was considered by the Court of Appeal, the weight to be accorded to any such rights has significantly diminished in light of the further evidence. So now that P wasn't living at home, didn't want contact with mum, didn't want a relationship with mum, and said she was complicit in her abuse, the assertion of her rights must cap and seriously diminish any Article 8 rights of her mother. Next slide. And so to ensure that P's participation in proceedings was facilitated and in P's best interests, her mother was discharged as a party again. And a neat summary of this is that to put the mother's rights before P would be to entirely subvert the purposes of the Mental Capacity Act. And the mother had argued that she needed to, or she should have the opportunity to put evidence challenging her daughter's allegations about the WhatsApp messages, about the abuse by those messages. And the court said she could nonetheless do that, but she wasn't going to be a party to proceedings. Next slide, Ray. I'm going to pass you over to Sophie now.
Thank you, Gemma. Really interesting selection of cases there. So the first case we're going to look at is this case called C, Capacity to Access the Internet and Social Media. And I've chosen it because it's a really good example of what the limits are of the second principle of the Mental Capacity Act, which you've got on the slide: persons not to be treated as unable to make a decision unless all practicable steps to help him do so have been taken without success. Can we have the next slide, please? Thanks. This case concerns a young woman called C. She was 28 and she had a moderate intellectual disability, as a result of brain damage, which sadly had been caused by meningitis when she was a very young child. And she liked using the internet like lots of other people, and she was found to have been downloading sort of very graphic sexual images which were found on her devices, and this led to a police investigation. The proceedings, I think, had obviously been going on some time by the time we get to this judgment, because the local authority had already been authorised to restrict her access to the internet and social media during the course of the investigation. The police eventually decided to take no action against her, and then the court then had to consider her capacity to make decisions about use of the internet. And this judgment is really largely about that. The court had heard evidence from Dr. Jo Lilly, who's a very well-known expert. And if we can move on to the next slide, please, Ray. Thank you. And as with any case involving the internet and social media, the two judgments of Mr. Justice Cobb, A and B, sort of loom quite large. So just a sort of reminder of those two cases, the judge had sort of considered for the first time how you approach assessments of capacity to make decisions about internet use and use of social media. And there's sort of two quite important, well, sort of two or three really important things in those judgments. The first is the judge's finding that engaging in social media, quote, for the purpose of contact is distinct from other forms of indirect contact. And it's also not part of care arrangements either. And he also said it's impractical and unnecessary to assess capacity separately in relation to using the internet for social communications as to using it for entertainment, education, relaxation, gathering information. So you end up with a kind of a fairly binary position. You've either got capacity to use the internet and social media, kind of all of it, or you don't. And the other useful thing about that judgment is that Mr. Justice Cobb sort of gives a guidance list of the sort of things that might be the relevant information for those kinds of decisions. I think the difficulty with that case remains that it's still a little bit unclear where the boundary is between contact, using social media for the purpose of contact, and actual contact. What happens if you're exchanging lots of messages on social media with one particular person, direct messaging? Is that contact or is it still social media? I think we still don't know that. But that's the sort of background. That was the authority that was weighing heavily in this case. Ray, could we have the next slide, please? So the evidence before the judge was that C had sort of very concrete thinking and struggled with abstract concepts. And Dr. Lilly in particular said that she just couldn't understand the idea of a stranger, and someone that she was in kind of friendly contact with would always be seen as somebody that she could trust. And the whole concept of a friend on Facebook who you didn't actually know would be, you know, really confusing to her. So Dr. Lilly's view was that she lacked capacity, and education would help, but there was still a real sort of hurdle to her making any real progress. So the judge accepted that C was close to capacity when she was given substantial help and prompting. And sort of often you'd be thinking, okay, so the next stage is going to be, well, she's going to get some input and that's going to help her gain capacity in the future. But that's not what happened here. Ray, can we have the next slide? So in this case, the judge accepted that that C, in order to use the internet or social media, would need so much help and so much prompting that she wouldn't actually be making a decision. She would just be effectively following the instructions of other people. And the judge accepted that there would come a point where the practicable steps to try and help somebody would tip over into actually making the decision for them. And he put that quite sort of graphically, that the individual concerned is little more than an automaton who is simply carrying out the instruction of others rather than responding to prompts and making capacitous decisions. And in this case, the degree of prompting that would be needed would mean that, you know, it would be a fiction rather than a genuine exercise in autonomy for her to be theoretically making decisions, you know, with that prompting. So she, you know, she is going to have the additional education, and it may well help. But this is quite an interesting case, I think, because it just exemplifies the fact that the help that you give someone to make a decision mustn't lead to you actually making the decision for them. So if we can have the next slide, please. So my next case is about personal welfare deputies. And this is CB, who again is 28. She had learning disabilities, epilepsy and autism and physical health conditions. And the litigation had been going on for an impressive 10 years between the local authority and CB's mother, and then between the local authority and CB's sister, who was the deputy for CB's property and affairs. And unsurprisingly, given there'd been 10 years of litigation, the relationship between YH, the sister, and the local authority had been difficult. However, it had recently improved. YH and the local authorities engaged in mediation, but the P hadn't been involved in that mediation because the official solicitor hadn't joined in, but it had obviously resulted in you know, quite an improvement. And the court was looking at two applications. One, whether to appoint YH as the personal welfare deputy for CB, and the other was an application about the local authority paying YH's costs. So if we can have a look at the next slide, we can look at the story so far with personal welfare deputies. So as you'll be familiar, the power to appoint any deputy stems from section 16, but that also includes the proviso that decisions of courts to be preferred to the appointment of a deputy, and that any deputy's powers should be kept to a minimum. The Code, the Mental Capacity Act, gives some guidance about when a deputy for personal welfare might be needed. And of course, the code was drafted before the Act came into force, so didn't have the opportunity of looking at any case law. And what it says at 8.38 is that deputies for personal welfare decisions will only be required in the most difficult cases. Doubt's been cast on whether that's correct by the Vice President in the Lawson, Mottram and Hopton case, where rather unhelpfully, I don't think I've put in the citation, but I'll make sure that's on the slides before they go out. The judge said that that part of the code requires to be revisited, but said that the structure of the Act and Section 4 may mean that in most cases, a personal welfare deputy isn't in P's best interests. So let's have the next slide, and we can look at the features that were in this case. So here, the local authority supported the appointment because they felt that it might keep up the improvement of the relationship between the local authority and YH. But the official solicitor opposed it. And the reason for opposing it was saying, well, this is the point of this application is not actually to allow YH to make decisions. It's just to try and enhance her position and improve the relationship with the local authority. And that was sort of borne out by YH providing a list of how she would use the deputyship if she was awarded it. And only two of this quite long list actually related to decision making. She wasn't going to be a carer, she was going to be living at some distance from CB. So in fact, she wasn't really going to be making decisions very much at all, but would be giving advice. So if you can have the next slide, please. So unsurprisingly, in those circumstances, the judge refused to appoint her. and said that the reality of this application is not to seek authority to make decisions, but it's in relation to status and a desire to be taken seriously and listened to by professionals. And it would be an inappropriate and impermissible use of Section 16. And for various reasons, the judge also refused the application in relation to costs. And so that's just a really clear reminder that you shouldn't be trying to, I think, manipulate the mental capacity. That's probably too much of it's probably a little bit harsh, but you shouldn't be trying to use those processes, such as the appointment of a deputy, for anything other than the purpose that they're intended for. I think this reflects the fact, perhaps, what YH really needed was to be properly consulted for the purpose of Section 4 of the MCA. And perhaps she hadn't been, and perhaps that was what was really important, rather than actually having the ability to make decisions. So if we can move on to the next slide, this is the last case that I'm going to talk about. And this is a case which went to the Court of Appeal, the Secretary of State for Justice and a local authority and others. So the first instance case was a judgment from Mr. Justice Hayden, Vice President, and it was all about whether care workers would be running the risk of prosecution if they arranged for P, who had capacity to engage in sexual relations but lacked capacity in a number of areas, to visit a sex worker for the purpose of having sex. And Hayden J had found that care workers would not commit a criminal offence if they were to make the practical arrangements for C to visit a sex worker. So that's the background to it. Can we have the next slide, please? So C himself did have capacity to engage in sexual relations and to decide that he wanted to have contact with a sex worker. He did not have capacity to conduct the proceedings, decide where to live, make decisions about his care, manage his money, or decide to use the internet or social media. He was actually deprived of his liberty partly because of the risk of sort of sexual violent deviancy at times when he suffered from intrusive thoughts. So the court wasn't actually asked to approve a specific plan, but just to give a declaration that the carers could go ahead and do this without actually running the risk of prosecution. So let's go on to the next slide. Thanks, Ray. The Sexual Offences Act creates a series of offences against people with mental disorder. And they all relate to people in positions of trust, obviously including carers. And Section 39 creates an offence, if carried out by a carer, of causing or inciting sexual activity. Now, so without going through the whole of the first instance judgment, Mr. Justice Hayden found that the purpose of these offences was to criminalise abuse of trust. It wasn't to stop people helping somebody who wanted to make an arrangement to visit a sex worker, because that was the only way in which he felt that he was going to be able to express himself sexually and have a sexual relation. And the carers, in Mr. Justice Hayden's view, wasn't causing the activity, but just assisting C. So there were also human rights aspects, and because the judge's interpretation of the Act was as it was, he didn't actually go on to consider them, but they were relevant in the appeal. So the Secretary of State for Justice appealed, and the case went to the Court of Appeal. So we shall look at the next few slides at what they said. So here's the grounds of appeal. The judge misinterpreted Section 39. It was contrary to public policy to sanction the use of a sex worker. The human rights conclusions were wrong. And the panel at the Court of Appeal was a pretty substantial panel: the Lord Chief Justice, Lady Justice King, and Lord Justice Baker. So a pretty sort of heavyweight group for the Court of Appeal. So let's find out what they said. Well, they started off by saying that the proceedings in the Court of Protection were unusual that is never a very promising start. And then they went on to answer a number of questions. So the first one is, can the civil courts even make declarations about the meaning of criminal statutes? The Court of Appeal reviewed a lot of authorities about this, and the answer is yes, they can, but only where the circumstances are exceptional and the reasons are cogent. The Lord Chief Justice doubted that it was really appropriate for the judge to have entertained the application in the first place. And Lord Justice Baker agreed and pointed out that although obviously Section 15 gives the power to make declarations, it doesn't say anything about whether conduct is criminal or not. Next slide, please. And the next question is, had the judge got the interpretation of the Sexual Offences Act right? No, he hadn't, said the Court of Appeal. First of all, you couldn't eliminate the risk that both C and the carers would inadvertently commit a strict liability offence under Section 53A. So that's an offence of paying for a prostitute who is being subject to force, for example, someone who's been trafficked. And the Court of Appeal was saying, you know, they couldn't possibly be absolutely sure that those were not the circumstances. And then the other point of the in relation to the interpretation of the Sexual Offences Act is that causation should be given its ordinary meaning. It's not a but-for test, and they look in the judgment at sort of authorities about causing death by dangerous driving, the difference between causing something where what you do is an operative cause and creating the circumstances in which it might happen. So your car's on the road and there's an accident that results in somebody dying. You simply having your car on the road at the time isn't an operative cause, but it might have created the circumstances in which something might happen. Next slide, please. And what about human rights? Well, the Court of Appeal pointed out that the Supreme Court has said that the domestic courts should keep pace with Strasbourg jurisprudence, but not go beyond it. There's no Strasbourg authority that recognises a human right to purchase the services of a prostitute. And the Court of Appeal said, you know, no surprise at all that that's the case. It's a really complex area with lots of moral and ethical and practical issues that where the court would give a very significant margin of appreciation. So it's very, very unlikely that Strasbourg would ever find such a right to be the case, and it hadn't so far. So the judge was being asked to go beyond the Strasbourg jurisprudence. And the claim that it was discriminatory was any potential discrimination wasn't without reasonable foundation in the circumstances. And very finally, a postscript. In his separate judgment, Lord Justice Baker reminded us of the three fundamental principles that he outlined in his very important judgment in JB about capacity and sexual relations, which many of you will know is currently before the Supreme Court. Those principles were autonomy, the protection of the vulnerable, and the need to adhere to the general principles of law. So in the and he went on to say that in a circumstances where P has capacity to engage in sexual relations, but for example, not contact, it might be lawful to make arrangements for that person to spend time with another person where the consequences might include the incapacitated adult engaging in sexual relations. So the examples he gave were two people, a married couple, one of whom has dementia. If you arrange them to spend time together, it's possible that they might engage in sexual activity, but you're not causing that. You're just creating the circumstances in which it might happen. And the next slide, please, which is my last slide. The merits of any such declaration would turn on a thorough analysis of the specific facts. The court would have to consider very carefully whether the steps proposed could amount to a criminal offence. And of course, if there was any declaration was given, it wouldn't bind the prosecuting authorities, although it might be taken into account. So those are my three cases. I'm going to hand over to Mary Rachel. Thank you.
Thanks, Sophie. So after Sophie and Gemma have done all the heavy lifting, you'll be pleased to hear I'm just going to speak quite briefly about two short cases, because I'm dosed with quite a bad head cold, so my voice is on shaky ground. So the first case I'm going to speak about is the one on the screen. That's Liverpool and CMW. CMW was a young woman who had recently turned 18. And this is a judgment of Sir Mark Headley, which looked at her capacity in 7 areas. So she has diagnoses of ADHD, fetal alcohol spectrum disorder, specific difficulties with cognition and speech and language. In the judgment, it's recorded that she doesn't have a learning disability, but that she does have a functional disorder. The judgment is quite scant on the detail, but it does say that she had a troubled history and was subject to a care order from the age of 5. And she'd recently given birth to a baby boy who was himself the subject of care proceedings and was in foster care. The judgment records that CMW's relationship with the child's father had been very important to her, though many questions whether it was in her best interests, and she hadn't had any contact with him since he was arrested for sexual offences. And it's unclear from the judgment whether those were committed against her. Next slide, please, Ray. So on the first issue, conducting proceedings, I can take quite briefly, because the parties were agreed that she lacked capacity to conduct the COP proceedings. But what was interesting was that she'd actually been found to have capacity to conduct the family proceedings, where her son was being taken into care. And Dr. Rippon, who'd provided evidence in the case, said that these two findings weren't inconsistent because the family proceedings were so clear and could be shortly stated, whereas the issues in the COP were potentially much more complex and much longer lasting. So the court accepted that she lacked capacity to conduct the proceedings in the COP. Next slide, please, Ray. Again, capacity to manage finances was uncontroversial in this case. The parties were agreed on it, and the court briefly considered whether P was just making unwise decisions, but was unsatisfied that she wasn't able to grasp the key ingredients for managing finances. And the next slide, please, Ray. So residence and care is what's interesting about this decision, really. And paragraph 13, the judgment says that that's the much more difficult and controversial issue. And the judge expressly considers the leading case of LBX and K, which everyone I'm sure will be familiar with, which sets out the relevant information for residents at paragraph 43 and the relevant information for care at paragraph 48. And so the judge in this case said, of course, generally speaking, questions of care and residence are considered separately, but there are cases in which they would be intimately related. And he gives the example of a person with serious physical disabilities for whom the issue of residence would be inseparable from that of care. And the protected person was rejecting care because they were unwilling or unable to recognize the necessity for their care. Then that would impact on the question of their capacity to make decisions about residence, where care would be a key ingredient. Next slide, please, Ray. So the judge basically said that that was the exact position with CMW, and that whilst she was able to understand, retain, and use and weigh the majority of the relevant information set out in LBX, she wasn't able to understand that she needs the care that she has because she seriously overestimates her own ability to keep herself safe, control her life, and underestimates the consequences for her welfare of independence. So he thought it was less a question of weighing matters, but actually a question of being able to understand some of the essential ingredients that needed to be weighed. Next slide, please, Ray. So paragraph 15 of the judgment is interesting because the judge says there, when dealing particularly with severe emotional difficulties and deficits, it can be very artificial to assign the relevant questions to individual pigeonholes. They're deeply interrelated and have to be considered in the round. It would be artificial and indeed wrong in this case not to consider residence and care together. So that, of course, echoes the Court of Appeal in B and the local authority, which emphasised the need to consider issues in context and association rather than separate silos. But in fact, Sir Mark Headley in this judgment goes a step further in identifying that there will be times when striving to assess capacity in such a decision-specific way would be artificial and indeed wrong, so he says. So again, I think residence and care can often be more complex than people think at first glance, because they can be so intertwined. And I think the message really is that it's fact specific, and it's about striking a balance depending on the particular case. But they probably shouldn't be separated out into silos in all cases. Next slide, please, Ray. So I can deal quite quickly with contact in this case as well. The judge accepted the evidence of Dr. Rippon that P lacks capacity to make decisions about contact with others. And this was due to her inability to understand her vulnerability and the emotional consequences of abuse and how she may be taken advantage of. And again, that was coupled with her serious overestimation of her ability to protect herself and keep herself safe. Next slide, please, Ray. On internet and social media, the judge again referred to Re B, which Sophie has mentioned, and said that one matter in the decision which exercised him was the question of understanding risk and danger to herself. Because on all other heads of the relevant information, P appeared to have capacity in this area. And the judge said, I don't think it's right simply to infer from her difficulties in appreciating safety and risk in relation to care, residence, and contact, that automatically deprives her of capacity in relation to the internet and social media. He said this was a much more precise and restricted area, and indeed with less call on abstract thought. So in fact, he found that she had capacity in regards to internet and social media. Next slide, please, Ray. And then very briefly on sexual relations, which was the seventh issue on which the court was considering. Parties agreed and the court accepted that P had capacity, even applying the higher JB test. And so given that she was found to lack capacity to make decisions about contact, but have capacity in relation to sex, the local authority accepted in this case, it would then have to draft up a TZ number 2 type care plan, which it would be doing in advance of the best interests hearing, which is yet to come. Next slide, please, Ray. So the concluding remarks just make out how sad the case is really. As I say, there was a lack of detail in the case, but it was clear that P was a very troubled young woman, had had a difficult life. And the judge acknowledged that, said it evoked his deepest sympathy for her, who'd been a victim of the doings of others over 18 years and more. But he did say that he'd reminded himself that I have to decide issues of capacity without regard to welfare consequences, which is an important reminder. I think we've all unfortunately seen capacity assessments which appear to work backwards with the best interest decision in mind, and that's wrong. It's obviously capacity first, followed by best interests. And if P has capacity, well, P has capacity, even if the local authority doesn't like it. Next slide, please, Ray. So the next case I can take quite quickly, because I see the time. This is a family court decision of Mr. Justice Hayden, very recent, just from a couple of weeks ago. And it's in fact an interim decision by the family court, but it's highly relevant to COP proceedings, particularly proceedings concerning parents or who have parents as parties, parents of profoundly disabled children or young people in particular. So it's the case of Ree W, and it was an application for a care order in respect of W. He's a 12-year-old boy with very serious disabilities, requires round-the-clock care. There was a private care agency delivering his care in the family home, and the agency encountered a great deal of resistance and what they perceived to be combative interference with their staff by W's parents, which unfortunately is something which might sound familiar to some COP practitioners. So the agency said they wouldn't be prepared to offer a service to W anymore because of the magnitude of the difficulties that they perceived the parents to be causing. Next slide, please, Ray. And the judgment records how shocked the parents were when the care agency withdrew. Again, that might be somewhat familiar. They thought they had an excellent working relationship with the care agency, and the mother acknowledged she'd been emotive, but emphasized how concerned she was for her son and how passionate she was. And she also recognized, though, that she was a prolific emailer. The court said it's a sad fact that the family court from time to time encounters parents of profoundly sick children or children with disabilities who become drawn into high octane conflict with the raft of professionals who seek to support their child's care. And the same, of course, can be said for the Court of Protection. And that's why I think this judgment really is helpful and one which all of us should read. Next slide, please, Ray. So in this case, interestingly, Mr. Justice Hayden approved the instruction of a consultant chartered psychologist and psychotherapist, Dr. Kate Helen, to provide a psychological assessment of both parents with the hope of achieving a better understanding of some of their interactions with the professionals. And Mr. Justice Hayden, in the judgment, describes the report as a landmark report, the analysis of which requires wider dissemination because it's so comprehensively captured the dynamic of this kind of conflict, and it really does. He noted the progress made in the proceedings since the report had been received. And in fact, that interim hearing was resolved by consent. He said it had unlocked the whole case. Next slide, please, Ray. So the judgment, unfortunately, doesn't exhibit the whole report. I don't know if it will be published in due course. I haven't seen the whole report yet, but there's a helpful summary of it in the judgment, which I recommend you take a look at. But I've got the summary on the slides there. So the psychologist said it's a complicated system around looking after W, who is obviously profoundly disabled. She said the stakes are very high. This is about keeping a child alive and ensuring his best possible quality of life. She acknowledged that care work was stressful, pressures on health professionals. Next slide, please, Ray. Just racing through these. And she also said feelings had run high, perspectives have become polarized and entrenched. And these are all words which will ring familiar to anyone who does COP cases with family members. And she said it had become difficult for the parents and for the professionals to respond moderately in ways that soothe rather than exacerbate the dynamic tensions between the different parts of the system. Next slide, please, Ray. So this was the crux of the report. She said, rather than looking to change the parents, I recommend systemic intervention drawn from organizational psychology, psychodynamic psychotherapy, group analysis, and systems theory, which all sounds quite complicated, but I think probably very helpful in this situation. And she said the intervention would assist all agencies and the parents to understand the dynamic processes that have led to the current difficulties, step back from mutual blame and recrimination, and establish working practices which will contain and diminish sensitivities, optimize collaboration. So Mr. Justice Hayden said, even before that work had begun, even just reading the report had really helped all parties to take a step back and acknowledge that perhaps they weren't communicating in the best way. Perhaps there was a lack of compassion and a lack of empathy, particularly for the parents, who were no doubt traumatized and really struggling with what was not an easy situation. And next slide, please, Ray. Just in terms of the relevance to the care proceedings, obviously the local authority had applied for a care order in this case. A court can only grant a care order where child concerned is suffering or likely to suffer significant harm, and that harm is attributable to the care given to the child, or not being the care not being what it would be reasonable to expect a parent to give to him. Next slide, please, Ray. And so Mr. Justice Hayden just gave some guidance that not being what it would be reasonable to expect a parent to give shouldn't be construed in a vacuum or applied judgmentally, and shouldn't be regarded as an abstract or hypothetical test, but evaluated by reference to the circumstances the parent is confronting. And Mr. Justice Hayden acknowledges in the judgment expressly that there's a similar dynamic often in court protection proceedings. And he said it's particularly common in the context of young adults in their late teenage years and early 20s, but by no means confined to it. And that's why I say I think this is a really helpful judgment for those of us involved in those sorts of cases, and perhaps a helpful one to provide to local authorities or public bodies who do characterize parents often as difficult and sometimes write them off. And it makes the proceedings and achieving any resolution of the proceedings very, very difficult when those entrenched views are there. So that was quite a canter through. I see it's 5:30, so we don't have much time, but if there are any questions, we're very happy to take them. Sorry for running over, but hopefully that was useful.
Thank you very much, Mary Rachel. That is a really interesting analysis, isn't it?
Yeah.
And it's quite relevant when you're thinking about addressing whether whether it's necessary to get a report.
I think so. And do we have any questions? I was just going to comment on another case of mine, if not. Oh.
No, I don't think we do. But if you do have any questions, just pop them in the chat, and we can, if people don't mind, we can stay on for a couple more minutes, either sort of discussing any issues from those slides. Go on, Mary Rachel.
Oh, just in one of my cases, and I'm instructed by the OS, and P's mother is seeking for P to return to her care, and this is one of the cases that Hayden. Similar to what Hayden mentions, she's a young woman in her young 20s, in her early 20s. And we got an expert report in that case to interpret her wishes and feelings, because there was a dispute about wishes and feelings. And the psychologist in that case interviewed P's mother, obviously, when reaching conclusions. And he made some really interesting observations about P's mother being traumatized by the care proceedings, which had led to her daughter going into care, and basically the ongoing battle that she'd had with health and social care, which will be really familiar to a lot of us. And so he recommended trauma-informed mediation for the family, the local authority, and the placement, because relations were so fraught. And he recommended a referral to Respond, which is an organization that we're very familiar with, Sophie, and I'm sure others will be. And that's a work in progress. But just to sort of give a plug for Respond, really, they're particularly good for that sort of trauma-informed work, albeit I know they're very busy, and it's reliant upon local authorities for funding those sorts of things. But it's worth bearing in mind for those cases where the positions are entrenched.
Definitely. We've got a question from Alta. But when it comes to vaccination COP cases, is there any guidance on who should be the applicant? Should it be a local authority or the CCG? Sometimes the CCG is not involved in funding. Really good question, actually. Gemma, do you want to have a go at that one? Or
Yeah, I mean, it's quite interesting when you look at the COVID cases, who the applicant's been. So in the one that I spoke about was the CCG, and it's not clear the circumstances in which the CCG became involved, presumably because ultimately they were responsible for the decision about vaccination if it'd been in the community, but I don't know, it doesn't say it in the judgment. There's other cases where the local authority made the application. I mean, ultimately, it should be, I would say, the decision maker. So that may even be the GP or the CCG if responsible. But if no one else does it, it's probably going to fall back on the local authority to bring the application. And there are those cases where either the local authority is already involved in proceedings, so makes an application with the input of health as needed, or they bring the application because they're involved in PES care.
I mean, I totally agree with that. And I'm just looking at our article that we wrote about it, because that issue came up a little bit. And in one case, the court found that Article 2 of the Convention, the right to life, was engaged by the application because the stakes, could be very high if he is vulnerable and doesn't have the vaccination. So, I mean, I think you're absolutely right. It ought to be the decision maker. That's probably someone in primary care. But I think that local authorities are being very wise and proactively bringing these cases to court when they're aware of disputes, and if nobody else is willing to do it. So I think that's probably as much guidance as we can give. So, Mary Richards, anything you want to add to that?
No, nothing to add.
Yeah. Anything else? Has anybody got any further questions? If not, I think given that we have overrun a little bit, we should probably say goodbye. Just have a quick thank you all very much indeed for joining us. Hope it was useful, and you will get the slides up on the website and the recording and the article for those of you who haven't got it. So thank you very much for coming. Hope to see you again, and goodbye for now. Bye-bye.
Thank you. Thanks, everyone.
Thanks, everyone.